Good morning, Coldwell Banker, George Realty. We're happy to see all of you here for the car commercial lease agreement. Peter, Cam, and Doug Meyer are also here, so you have a lot of people you can ask questions of if you have any questions. And we're going to get started. But one thing I wanted to remind everybody is October 31st in the Alhambra office, we're having a get together. We're really excited about it. We're all decorated up and we can't wait to see everybody here at noon for lunch and costume contest. So come on over and enjoy the food and the sharing with all of the agents. Okay, so I'm gonna share my screen and we're gonna get started. Okay. So I put the checklist up first. I'm not going to go over this whole checklist, but I just want to let you know, Anna put a lot of effort into putting these together. On the website, we have all of the checklists, so you can go in on the CBGR checklist and any type of deal you're doing, you can pull the list of the documents that you need. It's under the Sky Slope check and also, and I think it also says checklist. So go into the CBGR website. You can pull these lists. These are really great. I use them, check them off once they're done, and put them in your file or on your computer so you know you've gotten all the documents you need. So I just wanted to point that out. These are handy to have. So the tenant representation and broker compensation, I'm not going to go over this again, but I do want to point out one box just in case. So here, the amount of compensation, there is a mechanism here that you can check that the tenant shall owe no compensation. Now, why would you do that? Maybe you've already been conversing with the other agent and you know for a fact that they are going to pay commission, but that is up to you. But I wanted to point that out because somebody was asking me about this. If I have them sign it, does the tenant have to pay? Well, there is a mechanism to check. But make sure before you do that, that you know that the other side will pay. There is a form called the LCA, and you can use that to obtain your commission and ask the owner to pay your commission, okay? Even though it says housing provider all over it, Christine Finn was kind enough to call the hotline, and they said, yes, indeed, we can use that for commercial leasing as well to get paid, okay? So of course, when you're doing any leasing, you're going to have an application. So this will be filled out by the tenant, the guarantor, all tenants 18 and above, and the guarantor. Okay, so I just added that in just to show what's going to start. Notice, and this populates with the application, and we do require it. Now, every lease, you need to have an agency disclosure on it. When you're working with clients, even just doing the tenant representation, please include an agency disclosure, okay? So now we're going to get into the CCPA is required. It's on that list. We're going to get into the commercial lease agreement right now. So this is CAR. It's more simplified than I would say than AIR is, but it's perfectly fine to use. That is up to the property owner on the contract. So commercial lease agreement, of course, you fill in all the top. Here is the commencement date. The term begins here, and you have two check boxes. You can either make this a lease agreement for a certain period, like a year, and it'll terminate here. You put the termination date and the time. I usually put, 6 to 8 p.m. on them. I do expire the time as well, or it could be a month to month. So usually we're doing a lease agreement for at least a year here, okay? So A is normally what you're going to see checked. C, the renewal or extension terms. So here, if it's like let's say we have a 2-year lease, the tenant may want one 2-year option, one 2-year option. And I would also, if I'm representing the tenant, make sure that I put under the same terms and conditions, of this agreement. So here is where you will put the extension, or you can check this if it's too much to type there and attach an addendum. I'm on 2C. 2C. Okay. Patty is supposed to be bringing the forms in, so. See, that's under the commercial leasing. Yeah, so 3, the base rent. Right here, you see you have some choices here. So on the first one, it's per month for the term of the agreement. Make sure you read the fine print in these because you want to make sure you're on the right line typing in the rent. Or you can check per a month for the first 12 months, and then it'll increase according to CPI. For me, I don't know, I'm not that good at increasing per CPI. You would have the property owner would need to be doing those increases, and you have to insert the city. So there's that choice, or you have a choice here where you can check 3 and it's per month commencing and ending. And this goes on where you can step the rent up in box 3 for up to 3 years. Okay. So they've made that simple for you. You can step it up. If it's longer, you can also just attach an addendum with the rent schedule. Year 1 is this much, year 2, year 3, year 4, year 5. So that's up to you how you want to express that. But just make sure you don't get by mistake like on 1 and put the rental amount for the term of this agreement. Because if it was a 5-year lease, they'd be locked in at the same rate. So that's just something I want to point out. Make sure that you read these before you put your rent in there. And then the rent is payable on the first day of each calendar month, and it's delinquent by the next day. Okay, so that defaults to that. If you want to amend it, go ahead and amend it. Let's see. So the rent payment, you do need to put the name here of the rent, who it's going to be paid to. Oh. And also the address of the person or entity where the rent is going to be sent. So make sure that you populate that so it's easy for the person paying the rent to spot it. Okay. So early possession, you can put that here. I really don't prefer early possession because we want to make sure that we have liability insurance, everything's in place, the lease is signed, but that's again up to the provider. But if they do sign the lease early and the provider's okay with it, you would put the early possession date here. And also then you would need to check if they're obligated to pay rent during that early possession date. So are they obligated or not to pay rent? So that's your early possession. For here, I'm going to leave it blank in most cases because we're not going to have an early possession. But again, that's between the provider and to discuss with the agent. So security deposit, the landlord agrees to pay. The tenant agrees, and I'm going to use the words they're using in this lease to pay the landlord X amount in security deposit. And then there's a box here that you can check that if that base rent increases during the term of the agreement, that the tenant agrees to also increase the deposit by the same proportion. So sometimes that's important to people, sometimes it's not. So I just want to point that out. If you want it increasing according to the base rent increases, then make sure this box is checked. Okay. And the security deposit, as it said in the residential lease last week, they cannot use it for the last month's rent. Okay. So the payments, this will look familiar from last week for those of you that were here. You collect the rent from, and 2, you put the dates here, whatever the security deposit, any other category, it will total down. The due date, usually it's upon lease execution, but I do put a due date a couple of days ahead of that lease beginning, okay? So you want to make sure that this is paid, this initial amount. Please collect a cashier check for your client. Okay, so I always recommend it's a cashier's check. So these will look familiar from last week. The parking, the tenant is entitled to unreserved or reserved. Parking is or is not included. For me, I always type in the additional terms that because most of the projects that we're on, those parking is first come, first serve. So even with the occupant, the tenant, they don't have a lot of times reserved parking. So it may be in a different structure or a lot, but it's first come, first served. Okay. And if that's the case, make sure that you do note that. Additional storage, a storage is permitted as follows. If there is an additional storage area, the right to additional storage, usually I'm checking that it is not included. It's only in the unit, okay? Late charge. Tenant shall pay to the landlord X amount as a late charge here. So you have to remember to insert an amount that you discuss with the property owner. What do they want to charge for a late charge? Okay. And then plus 10% per annum on the delinquent amount.
Do you also discuss that with the tenant? Like, here, the late charge, in case you're late, this is what I'm going to charge you, right?
Yeah, this is what the property owner will charge if you're late. Yeah, you want to point this paragraph out when you're having them sign it so they understand what the consequences are if they're late on the rent. And then additionally, there's a $25 return fee for NSF, but that might not be enough. So you could cross that if it's not enough and it's $35 or $40 at the owner's bank. You could put that in additional terms and amend that amount. So that's entirely up to you. Okay.
Yeah, I know they're like $35.
Yeah, I think it's higher than 25. Condition of the premises. Tenant has examined the premises and acknowledges that it's clean and in operative condition with the following exceptions. So what you need to do when you're representing the tenant is make sure that you're doing a walkthrough with them. Make sure that they go through the unit. Their contractors have been there, whatever they're going to need to do. Have that unit available, advise them that they need to be checking the unit out with a contractor or whatever they're going to do. If they're doing a lot of remodeling, you're going to need to have that checked out. So zoning and land use, the tenant accepts the premises subject to all local, state, and federal laws. The landlord isn't making a representation to the tenant that the premises are now or in the future will be suitable for the tenant's use. So usually when you're working with a tenant and they're going to open, of course, you're going to interview them. What kind of business are you looking to open? You always want to advise them to check with the city. Go ahead and check with the city. You also, if you're a listing agent, are going to be checking with the landlord to make sure that it's a use that they can handle there, or maybe another tenant in that complex has exclusive use on that same usage. So, you're going to check with the landlord or the landlord's agent, and the tenant should be checking with the city for their use. So tenant operating expenses, excuse me, the tenant does agree to pay for all utilities and services directly billed to the tenant. If there's something else that the landlord needs to add, you can amend that. Now you look down here at 14, property operating expenses. So the tenant agrees to pay its proportionate share of the landlord's estimated monthly property operating expenses. Or you can check B, that this paragraph does not apply. Maybe on a smaller unit, it's just the straight rent and that the tenant pays the utilities. Or maybe it is that they're going to need to pay some other common area maintenance fees. So you need to be asking that of the listing agent. If you are the listing agent, make sure you know ahead of time from the owner what they are going to expect the tenant to pay on that unit. And that this box here, if it's B, then make sure it's checked. Use is very important. So make sure that you are including the use here. It's important for contractually, because if they started switching up on the use, they need to stay with the contract. So make sure that you have the use in there, that you've gone over it with the tenant, that they understand That's a very important box. That's something not to be missed. So the rules and regulations, the tenant does agree to apply with, the rules and regulations of the complex, the landlord. So maintenance on 17. So they've made these three boxes that who will generally pay, or you can check it to the other party. So on A, the tenant, or if you check it, the landlord shall professionally maintain the premises, including heating, air, electrical, plumbing. So usually on the interior, the tenant is going to take care of that. If they are maintaining the air conditioning, usually they need to be doing it quarterly or every 6 months with a professional HVAC company and have evidence for the landlord. So those are things as a listing agent, you need to be asking the landlord, how often do you want them to maintain that HVAC unit? It's very important. So tenant, or if you check at the landlord, excuse me, shall keep glass, windows, and doors in operable and safe condition. Generally on that, I have seen that it's mainly the tenant. I believe, and Peter can correct me if I'm wrong, there's even plate glass insurance, isn't there, Peter?
Yeah, yes,
Yeah,
yes.
yeah.
Yeah.
So
It's
there's
not
glass
important
insurance.
for commercials, yeah.
Yeah, because those windows can be expensive. So there's also insurance for those plate glass windows that the tenant can obtain.
That's what my son does for big Macy's in New York.
Oh, okay.
Nationwide company.
Yeah. So on C, this is generally a landlord's expense. Landlord, or if you check it, the tenant shall maintain the roof, foundation, exterior walls, and common area. And you can add here, generally you're going to let this one default because that usually is a landlord's, work. Okay.
Michelle,
Uh-huh.
in that one part on 15, where it says the premises are for the sole use as,
Yes.
that would be an example as for
Ready to for a
massage
parlor,
parlor, shoes,
Barber shop. Yeah.
shop.
ice cream parlor, or something like that. Really wanted this.
Yeah, and it's really important because if they don't, if they start doing a different use, the landlord has a right, like if any use causes an increase in the premium. Well, this is for any use of the landlord's existing property insurance, then the tenant needs to pay the increased cost, and that's for any use. So if they're using that unit and it's causing an upper on the landlord's insurance policy, the tenant is responsible for that upper on that policy. So this box is really important here, number 19. Government imposed alterations. Any alterations required by law as a result of the tenant's use shall be the tenant's responsibility, and landlord shall be responsible for any other alterations required by law. So me and Peter were talking last night. When you are representing a tenant, and you can even ask the landlord if you're the listing agent, a lot of the units are going to have a private bathroom in them or two. Ask them if they're ADA compliant. You can ask that ahead of time. If you are writing an LOI and representing a tenant, put it right into the LOI that the bathroom shall be delivered ADA compliant. Now, does that catch everything in the unit that may need to be compliant with ADA? No, I saw on one unit we leased, there was a backdoor issue and it cost the tenant like $600 to remedy. But the big one, make sure the bathroom, if you are representing people or bathrooms, ask if they're ADA compliant. Anything else, Peter, on that?
Yeah, that's very important because you want to make sure that there's ADA compliance before the tenant move in, because after you move in, then the tenant's responsible for all the violations and if you have a ADA lawsuit, the tenant is responsible for half of the amount. That's usually what it is. So before you let the tenant move in, you better make sure that is ADA compliant. And also, ask the landlord whether they have a CASP inspection or not. Usually, most of the landlord they don't have it, but at least you ask them whether they have it, and if they have it, ask them for the report, so that when there's some a problem with the violations, or if somebody sue for ADA and non-compliance, then you can have it as a defense.
Okay, thank you.
Now, can I ask you something, Michelle?
Uh-huh.
Okay, with the a compliance. If they go there and the owner does not want to change the restrooms to that, it's for the tenant to do it, right? If he wants that space. And they agree to it. Yeah.
Right, and what I've seen.
But the owner does not have to do that.
No, but a lot of times, like if they're going to do a major remodel, it may not be as big of an issue. If you're talking about 1,000 square foot unit without compliant bathroom, it is a big issue. So if you find that the landlord does not want to make any corrections in the unit, they need to get a contractor over there and get a quote. Don't have them sign a lease blindly, because it can be a blank check. We try to head off with our experience for the client as much as we can. Like I said, we head off the bathrooms for sure. But I saw a unit where a back door was an issue, but really we couldn't head that one off. But luckily it was only 600, right? But you want to head off those main things.
Okay, same as the termite inspection for a residential.
Yeah.
First thing I do is get an inspection.
Yeah.
That way you know what you're negotiating on.
Right.
Now, if the landlord doesn't want to do it, you can ask for them for rent concession, maybe a few $100s, for the correction of the ADA, the bathroom. That's reasonable.
Mm-hmm.
Well, the landlord can ask for concessions.
The tenant would ask the landlord for rental abatement / concessions to cover the expense of rehabbing or upgrading that bathroom to make it ADA compliant.
Okay. Might have to go back again.
Yeah.
Good understand. Okay, gotcha.
Can I interject something here?
Yes.
Okay. When you're going to have the tenant do the improvements like the ADA bathroom, sometimes the city requires that they get a city permit to do it, because you're modifying the space and the use. And then you have to have the fire department come and inspect it, because they want to make sure if there's a fire that they know where everything's at. The police department has to be made notified, because if something happens, they need to know if there's somebody in there or whatever. So it could delay the opening of the lease. So be careful about that.
Right. And the contractor you get a good licensed contractor, they're going to handle all those inspections. The fire department looks for among other things, they're looking at the sprinkler system, So when people have removed rooms or added rooms to units, they actually had to go in and add additional sprinkler, heads. So a good contractor is going to be the leader on all of that. Thanks for bringing that up, Franco. Those are very good points. So make sure your contractor is licensed, and knows what they're doing on this stuff, because they're going to have to manage those inspections. Okay.
Don't tell anybody I was helpful.
Well, I appreciate you bringing that up.
You should be. Hard.
So entry to the unit, the landlord and tenant agree that a 24-hour notice, either oral or written, is reasonable and sufficient. If an emergency, of course, the landlord or the landlord's rep can enter the unit at any time without prior notice. Okay. So signs, the tenant does authorize the landlord to place a for sale sign on the premise at any time, and a for lease sign on the premise within 90 days, or you can amend the days prior to the termination of the lease agreement on that unit. Subletting and assignment, that shall only occur with the landlord's consent. Whoever they're subletting or assigning to is going to have to go through the process of submitting an application, credit report, all of that. I want to point something out that I've underlined here in red. It does not release the current tenant of the tenant's obligations under this agreement. So a lot of people may not be aware of that. So if you do a sublease or you're subletting or you're helping somebody, and the prior tenant wants to be released, make sure that's embedded in the contract, okay?
Now, I have a comment on that, Michelle. Most of the commercial the lease agreement have this kind of provision, but if you have an anchor tenant that's very powerful anchor tenant like like Ross and or the Office Depot, a lot of time they will say that once they assign the lease, their obligation is terminated. So you have to read that lease very carefully when you are leasing it to the anchor tenant. So it's not all the time that they have such a provision that the tenant are not release of the obligations. So that you have to be careful.
Yeah, thank you, Peter. Yeah, that's something to really be watching for. So when we do these trainings, we're trying to, I'm not going over each paragraph, but we're trying to head you in the direction of things that you really need to be watchful for. And then if you did need further instruction, we're always available for that. Okay. I'm going to drop down. So here, these are just things I think you should read. Read these paragraphs: breach of contract, early termination, how that works. So the tenant would be responsible for the lost rent and anything like that. And they are responsible until the landlord is able to re-rent it, or that the landlord releases them from the agreement. Okay. So a lot of times I think, Peter, that the landlord would release them. So, they're not messing around with them anymore, but that's up to the landlord, and they're going to concurrently trying to be renting it. So, but the prior tenant would be responsible for the rent up until the time that the landlord can put a tenant in there, or the landlord's elected to release them from the contract. The tenant should not be storing or generating or releasing hazardous material on the premises. Okay. So if they cause any contamination, the cost of that cleanup is paid by the tenant. So insurance to me is huge. Make sure before you give the keys or possession of this unit that the tenant has turned over their liability insurance, okay? In the amount not less than, you talk to the property owner, how much do they want here? So this contract, now AIR will say that the landlord doesn't have to give you the keys unless they have this certificate. This contract does not say that, but I would like to recommend that the keys are not turned over until you have a certificate of insurance. You have any comments, Peter?
Yeah, that's very important because anything can happen during the time, And if you don't have, if the tenant doesn't have the liability insurance, all their responsibility will be on the landlord, and you don't want to do that. You don't want to overburden the landlord with something that's unknown, So it's very important that they have that insurance in place before you turn the keys to them.
And there's some in the back of the contract, you can put other terms and condition, and you can reference this paragraph and put that landlord will provide keys on commencement date, subject to receipt of the certificate of insurance from tenant. Okay.
Mhm.
So you can make this contract more tight on that so that the tenant will understand. We'll give you the keys on commencement date and subject to the receipt of this document. Okay. This insurance document. Tenancy statement, the estoppel certificate. The tenant needs to return to the landlord within 3 days after receipt, after their request of this document. Maybe the landlord's lender needs it. You know, there could be a multitude of reasons other than, you know, sell. So they need to turn it back over to them within 3 days after receipt of their request. So on 33, the tenant represents that everything they said on the application is true and correct. I like this paragraph because, you know, the landlord has a right to have true and correct statements, and this is representing that the tenant has given you true and correct statements on the applications, okay? Now, 34 is the one that we've talked about a little bit up above. This is the construction related standards. Right here, don't miss this paragraph. On A, the landlord states that the premises have or have not been inspected by, like Peter said, certified access specialist. Most of the ones I'm on, it's have not been. It doesn't cause any issue to check that, but you need to make sure that you're checking that they have or have not. And if they have, then it's going into that the tenant shall receive a copy of the report.
Mhm.
So please don't miss number 34, checking either have or have not been. And then I want to make sure that you don't miss D. Okay, so right here on D, you have another obligation to check a box. So notwithstanding anything contract to the upper paragraphs or elsewhere in the lease, any repairs or modification necessary to correct violations of construction shall be the responsibility of tenant or landlord. Make sure that you're checking one of those boxes. Of course, if I'm working with a tenant, I'm going to check to landlord. Maybe they'll counter that, but you know, do you have any comment on that, Peter?
Well, usually you have the responsibility of the tenants for anything that's interior to their premises. And anything
Okay.
that's a common area is the landlord's responsibility. So you can put it under
On
the
other.
others and specify that, you know.
Yeah,
I
you
think
know
that will
that
move there.
that's good, Peter, because I didn't realize until recently, I don't know why, I think I was asleep on this one, that even use can trigger I'm not talking about ramps or handles, but it can trigger other ADA compliance
Mhm.
outside of the unit. Like,
Yes.
yeah, and I didn't know that. Like that can be, you know,
In other words,
interesting.
ramp, entrance, and then
Even the
back.
sidewalk, even stuff on the sidewalk, as I recall, on one unit. So yeah, that's a good
Yeah.
point, Peter.
Mhm.
Okay, what Peter just said, he's saying that the landlord is responsible for the outside,
Yeah, go ahead and ask him.
the outside, and the tenant is for the inside. Am I right?
Yes.
Okay, that's just like a condominium. You know, when you're in a condominium, whatever's inside, the tenant, that's theirs, you know, the owner. And outside,
Well,
the
in the
association
on the
take care of.
condominium, it's not that much of a problem because it's not publicly as accessible, you know, for residential. But for the business, we're talking about the commercial now, Catherine.
Okay, but I
Yeah.
was kind of relating that to that, but okay, gotcha.
Yeah. Okay.
Um, you know, up in Pasadena, there's a jewelry store in a shopper's lane. I don't remember what the name of the shopper's lane is, but they had a two-step downstairs to get into the store.
Ooh.
And somebody tried to sue them for not being ADA compliant, but there was no place where they could put a ramp without structurally modifying the building. And that would cost more than 10 years
Yeah.
worth of rent for the tenant.
Yeah.
And they got away with not having to do that.
Yeah,
So
that's hardship. You're pleading hardship. Yeah, you're right.
yeah, sometimes it's a case by case thing where if it would cause structural damage to the building, such as where you have masonry work by the entrance and the whole wall, the whole
True.
front of the store was all bricks.
Yeah.
Well, you know, they would have to cut the bricks, restructure everything,
Yeah.
and it might cause structural damage to the upper floors, collapsing onto the ground floor unit that was there. So they
Right.
got away with not having to do it.
Yeah, good point there.
There,
Mhm.
sometimes I've known this and I've heard and I've seen it. I read stories about where there's a guy in a wheelchair that would go around certain commercial buildings to see if they're handicap accessible.
Yeah.
And if they weren't, he would right away sue them.
Yeah. Yeah. It's something
had-
that we need to be aware of.
20 or 30 lawsuits against different
Yeah.
owners.
Did they
Yeah.
pay them all?
I don't know, some did, and some are fighting. But I know that he was everywhere, always going to different commercial buildings and checking them out. They were handicapped, so he would go in, the bathroom is not accessible.
Yeah.
So,
You know, when Franco was talking about those other things, it made me think of something else to be aware of. Sometimes you have commercial units that are sitting below, you know, condos, and it's called a mixed use building, as we all know. If you are in that situation, make a note in the lease that if the leaks occur from the units above into the interior, that the landlord would be responsible, because you know, if we go strictly by interior, you know, they're going to go, oh, that's a leak inside your unit. But you want to make sure that if it occurred above from the mixed use from the residential units into that unit, that the landlord would be responsible for fixing. Because we went over something like that just recently, just to give you a little tip.
Yeah,
So
good point there.
yeah. Is that, Peter, is there a way to structure it? Like what would they say just if it's the units above that cause the leak, right?
Yeah, well, the primary responsibility will be the tenant upstairs, but then if the tenant upstairs don't want to be responsible for it, then the secondary responsibility is the landlord.
Okay,
Yeah.
okay. So mediation is baked into this contract, and you see it says right here that this provision applies whether or not the next page that the arbitration is initialed. So this is up to the tenant and the landlord about arbitration. If they wish to sign it, there's initials here. They can make their decision about that, correct, Peter?
Yes, but before that, you have to explain to them what is the advantage of the mediation and arbitration versus a regular lawsuit. A lot of people just assume that the mediation and the arbitration is the best way and the cheapest way, but it's not usually the case, because arbitration can be very expensive. You know, arbitration can be more expensive than a regular lawsuit, because the arbitrator are very expensive. They charge you $750 to $1,000 per hour on arbitrating the case. So by the time you finish the arbitration, it's like, you know, 30, 40, $50,000 arbitration fees, you know, and that's not necessarily good for the tenant or even the landlord, you know. So make sure that they understand what is the pros and cons of the arbitration clauses.
So is that what you explained to the landlord? I mean, to the homeowner
Yeah.
about an tenant before they sign an initial or before?
Yes, yeah, exactly. You have to explain to them what's the process of the mediation and arbitration, what's the advantage and the disadvantage, you know, And then sometime, if the claim is less than 12,500, you can go to the small claims court instead of going to the mediation or arbitration. Much less expensive.
Okay. Perfect.
So on 37, like the residential lease agreement, if there's more than one tenant that signed that lease agreement on this commercial unit and one bunks out on the other one, they're individually responsible for the full rent, okay? Either together or individually. So if you need to add other terms or tighten some up, you have space here, or you could also add an addendum. If you have any attachments, you can put the document here. Option agreement to purchase. Yeah, usually not, but that's up to you guys. But you can put your other contractual documents here that you are attaching and making part of this agreement. For instance, addendum 1, addendum 2, whatever you have going on. The attorney fees is paid, reasonable fees are paid by the prevailing party should a lawsuit occur.
Thanks.
And this is the entire contract. And landlord and tenant shall each pay the broker the fee agreed to, if any, in separate written agreement. So make sure that you do have your written agreements for your commission. It says it right here in separate written agreement, agreed to in separate written agreement. Okay. So that is the end of it. If you have an entity tenant, check the box, fill out the authorized signer. What is the name of the entity here? Have everybody sign it. Very important not to miss the guarantee box. If this lease needs to be guaranteed by anything, click the box. Put the name and information here and have them sign and date it. Okay, so the guarantor is also going to need to fill out the full application, run a credit report, of course, and all of that. But don't miss that if you intend to have a guarantee on this document. Okay, and this is a landlord's page. So I think that concludes. I have one other thing to show you. I have a list.
What do you mean by guaranteed?
Guaranteed, who's ever going to guarantee the lease? Let's say they say, okay, we'll take this tenant, but we need somebody to guarantee the lease.
So like who would guarantee?
Somebody that's financially able. Yeah.
Okay.
In other words, if I was to rent the place, so Catherine and I were to rent the place.
Like a co-signer.
Like a co-signer.
Yeah.
Okay.
You say co-signer.
So I have if you really want to get into commercial, I have a list of 8 of the most typical types of commercial real estate leases, and I can send that out if you're interested in that. But again, if it's something you're interested in, I'll send it out so that you have like a little cheat sheet about what triple net means, modified gross, and all of that. Okay. Any
I'd
questions
like to get
for
a copy
Peter?
if I can.
Yes.
Thank
Any
you.
questions?
Michelle, before you conclude, I have a few comments.
Okay.
Regarding the first one comment I have is that like the commencement date and the rent date is not necessarily the same. So because sometimes a lot of times you have a rent abatement, the 3 months or 6 months rent abatement, or you want a TI for the tenant. So the commencement date is the date that the lease is effective, but the rent start date is the date that you start paying the rent. So those 2 days are not necessarily the same. So you have to make clear which one is which, okay? And don't get it mixed up, and also don't confuse anybody. Make sure that you have the specific days for each of those 2 days, okay? Now, for the increase in rent, according to the CPI, usually before we usually that automatically we say that, well, we have increased it according to CPI, but a lot of times the CPI they have different areas, So which area of the CPI are you referring to? So instead of just saying CPI increase, you kind of predetermine what the rent increase will be. That's better, and it's more clear instead of having to rely on the CPI, and then each party will have to go to verify what the CPI at the end of the term, at the end of the term of the lease. So well, usually, you just specify that that increase, that the rent increase will be 3%, 5%, or a specific amount. That would be much better. Okay. Now, and also for the security deposit, it's not there's no maximum in the security deposit for commercial leases. Okay, but nevertheless, you have to be reasonable. You cannot charge like 6 months or years rent as a security deposit. Usually, 3 to 4 months is reasonable, and you have to stay within the range. Otherwise, the court will say that it's not reasonable, so they will invalidate your security deposit. And then lastly, when you before you sign the lease, you should, if you are representing the tenant, you should have a contingency on getting the city's permit to do the business what the tenants intends to do, because it can be a lot of variation. A lot of the cities have different requirements. They have different zones for different businesses. So you don't know beforehand. So if you sign the lease, you better protect the tenant putting the contingency to have the permits from the city. Sometimes they have to do the CUP, which is conditional use permit, and it takes a long time to do. So you have to let the tenant know ahead of time too. That's one of the things that they have to find out before they sign the lease. Okay, so that's a lot of things that you have to be aware of in the commercial lease that you normally don't need to worry about in the residential. And Michelle is very experienced in this area, and she has a lot of different forms of leases, and a lot of the forms are drafted by the real estate attorney. So they might differ from the forms of the CAR or differ from the form of AIR. So you really have to read it carefully if you are presented a commercial lease from the other party. Okay. And you just have to be more careful. Okay. All right. That's all my comments, Michelle.
Okay, great. Those are wonderful. Thank you, everybody. Are there any further questions before we?
Yes, Michelle. Hi, this is Steve. I just don't know on the type of leases you are going to provide to everyone. Do you include in the IDG, industrial growth?
No, I'm just the 8 typical types. I can put that in here.
Yeah, because just a reminder for the industrial properties, usually the AIR use the so-called IDG, industrial growth, and that is not the same as the typical even growth lease. So pay attention on that. IDGs, usually they are going to set up a base year, and any searches the property tax, say the 2023, 2024, let's use the wrong number. Your property tax is 10,000. Then 24, 25, the property tax increased to say 10,300. The tenant is going to be responsible for the payment of that portion, and maybe other, of course, increase of the HOA or something like that. So that is the IDG. In the industrial lease, AIR contracts more complicated than CAR.
Yeah.
So
definitely.
Yeah.
And Steve, bringing up that's a good point about property taxes, which this lease doesn't cover all of that, but you can limit the what we try to do on some of the contracts is limit the amount that the tenant would be responsible by expressing it in a percentage that they would, not higher than, X percent, of increase
Yeah.
for property taxes. Yeah.
Yeah. Yeah, you should insist on the Proposition 13 protection on the property tax, Otherwise, if the landlord sell the property and then they have
Yeah.
a big gain in value of the property, then you have a very substantial increase in property tax, and it's not fair for the tenant to bear that,
Yeah.
Can I make one last comment?
Sure,
Yes.
Franco.
Okay, one of the things you have to watch out for is we could write a lease and the company that represents the owners say, oh, we have our own leases, like Dom or Richard Ellis and stuff like that. Be careful when you get their copies of their leases that everything that the tenant is responsible for is not over and above what you had requested, because sometimes they'll mark tenant all the way down, and it could be thousands of dollars that they're responsible for. So be careful. You got to read the contract before you have your client sign it, and then counter that out.
Franco's a nice guy.
Don't tell anybody that.
Yeah, that's true, Franco. You got to do a lot of reading and take care of your client. That's a good point. When you get different contracts, AIR, you kind of know them, in the commercial arena, but there are a lot of contracts that come out that are written, like Peter said, by attorneys for the landlord. So we have to really be on top of our game and read them.
Right.
Yeah. And I would also go further to say, you read them too, but advise the tenant that they could have their own attorney read these agreements as well. As a real estate agent, you can read them, but and make your suggestions or point some things out. But I would say have an attorney review them for the tenant as well. Any other questions?
Yeah, that trigger another questions, I remember once we have a training by an attorney talking about the contract, and I remember he said, you are the marketing guy, you are not the legal guy. And it is better not for you to try to explain what this language means, because just by one of the on or in or ad, the whole paragraph could be changed. So I remember that attorney said, whenever your clients ask you about, can you please explain on this paragraph for me? And his advice is just read through the paragraph. I said, wow, that is smart, So, usually for these kind of huge commercial deals, I always advise my clients, consult with your attorney. Have your attorney go through that, because that is the best protection you're going to get.
Right.
Particularly when you have some big commercial companies, even on their lease agreement, do you know they can change inside? Searches, they can modify some language inside there. When you got one lease agreement or purchase agreement, you assume, they are all maybe in a template. No, it is not. So be very careful. All these kind of major commercial searches, you mentioned about the Ross, they have their own lease agreement. I will tell my clients, go ahead to see your attorney. Don't ask me. I'm on the marketing guy. I'm the legal guy. I don't know if that's the right advice or not, but all these kind of major commercial, be careful.
Yeah.
Right. Good suggestion.
Thank you, Steve. That was really, good to hear. Thank you very much. Anybody else? We'll be concluding then. Anybody? Okay.
Thank you, Michelle.
Yeah. Thank you, everybody, for attending.
Thank you.
Yeah, we
Have a nice
appreciate
weekend.
it.
Thank
See you
you.
next
See you in the Halloween
Don't
party.
forget about Halloween. Yes.
Halloween.
Yes,
Boo, everybody. It's going to be fun. Bye-bye.
Bye.